Good evening, everyone. So we're done with partnership. Now we move to corporations. So probably by now, you have a good idea about sole proprietorship, about partnership, and now I hopefully we can learn something more about corporation. I hope I can add more to what you already know about corporation. So, what is corporation? So, from your own knowledge and past subjects, I think you know what a corporation is. You have a basic idea of what a corporation is, especially if you are like you, business administration students. Ang alam ko, second year, third year pa lang exposed na kayo, how much more fourth year. Okay? So, corporation as defined by RA 11232 are corporations are artificial beings. They are created by operation of law. So, meaning when we say artificial beings, di ba we discussed earlier that there are two kinds of persons. You have the natural person and then you have the juridical person. Ayun siya. It's an artificial being. Okay? Created by operation of law. So it is not the agreement or the consent of the parties that creates or that gives birth to a corporation. Hindi yung hindi yung consent, hindi yung agreement, but operation of law. It has a right of succession. Comparing it to partnership, like what we have discussed before, partnership, kapag namatay ang partner, dissolve ka agad. Diba? Kapag mayroong bagong partner, dissolve ka agad. Diba? Unlike corporations, okay, mamatay man yung isang stockholder, mamatay man yung, may bago mang stockholder na pumasok or may magbenta man ng kanyang stocks, meron pa ring continuous ang life ng corporation. Okay? And it has powers, attributes, and properties expressly authorized by law or incident to its existence. Okay? Those powers, attributes, and properties, meron siyang similarities with regards to a partnership in a sense that it can buy and sell properties. It can sue. It can be sued. Diba? It is represented by its corporate officers and its board of directors or board of trustees. Okay? Doon sila nag-aak ang corporation. Kasi ang partnership, para mas maintindihan nyo, di ba ang partnership, a partnership can only act only through its partners. Pero kapag corporations, it acts through its corporate officers and its board of directors or board of trustees. Okay? Now, with that definition, we can now compare and distinguish between a corporation and a partnership. So fresh naman yung partnership knowledge nyo. So it's you can picture this clearly in your mind. So when as to manner of creation, sabi nga natin kanina, corporation is created by mere operation of law. Okay? Hindi by consent, hindi by agreement like partnership. Okay? Why? Because you have to follow the laws as regards to creation of corporation. Okay? Number of organizers. Ito ang bago din. Because what we have now is not the corporation code, but we have the revised corporation code. Okay? Yung bagong law. Before this law, hindi pwede ang sole corporation or yung single-owned corporation. But now, pwede na yung isa lang. O, di ba? singly or jointly with others but not more than 15. Of course, meron pa rin yung limit na 15. But now, pwede na kahit sole, kahit isa lang. Okay? Unlike to partnership, kailangan dalawa. Partnership nga. Hindi naman pwedeng partnership kayo ng sarili mo. Di ba? Ano yun? Baliw ka na. Di ba? Hindi. So, dapat 2 or more sa partnership. Right of succession, yes, for corporation. Sabi ko nga kanina, even if a stockholder dies, even if a stockholder sells his interest or admits new stockholders, the corporation life still continues. Unlike for partnership, once a partner dies or may bagong na-admit na partner, the partnership will be dissolved. It may be continued, but it is now a new partnership. Okay? As to limitation on powers, only those expressly authorized by law or incident to its existence. So, medyo strict on that part sa corporation. Okay? As to partnership, there is no limit. Sabi nga natin, as long as you agreed on it, as long as the partners consent on it, as long as it is not contrary to law, morals, good customs, public order, or public policy, those acts or those powers are valid. Okay? In terms of management, yan, kaiba din. For corporation, you have the board of directors or board of trustees. And for partnership, you have the general partners. But hindi kasaling limited partners because as we have discussed previously, limited partners don't involve themselves with the management of the partnership. If they involve themselves with the management of the partnership, di ba, maging liable sila like general partners. Okay? Liability for debts, ito yung medyo talagang hindi sila magkaparehas pero merong konting similarity. Why? For corporation, not liable for debts of the corporation, but for partnership, liable with their separate assets for partnership debts. So, in short, for corporation, you have limited liability. Meaning, kung ano yung shares, yung value ng shares or yung value ng stocks mo, yun lang yung pwedeng mawala sa'yo. Okay? Kapag nalugi yung corporation, yun lang, walang habol sa'yo. Unlike for partnership, especially if you're the general partner or a general partner, you are liable with your separate assets for partnership debts. Yun isang advantage if you try to form a corporation. But the creation, the formation of a corporation, and the regulations that you have to abide are much more tedious than for a partnership. Okay? Kasi ang corporation, ang reporting authority mo dyan, ang regulating authority mo dyan is the SEC. Okay? Although you still have to submit articles of partnership with the SEC, hindi ganun ka-strict ang regulation with regards to partnership. Commencement for existence, date of issuance of certificate of incorporation. Okay? Tandaan nyo, corporation life only exists upon issuance of certificate of incorporation, not upon agreement, not upon consent, not upon execution of partnership contract. Okay? Unlike partnership, gaya ng sabi natin noon, if maalala nyo, okay, partnership life begins upon execution of the partnership contract. And when is the partnership contract executed? When the partners deliver their promised contributions. Okay, doon mag-give birth yung partnership life. Okay? As regards to transfer of interest, yes, even without consent of other stockholders. Diba? If you are a stockholder of a certain corporation, you can just buy and sell stocks. without informing other stockholders. Yun yung isang advantage ng corporation. Okay? Or ng stockholder sa isang corporation. Unlike if you're a partner in a partnership, yes, you can sell your interest, but he does not become a partner. Okay? He becomes a partner only with the consent of other partners. Okay? As regards to term, corporation, perpetual. It has a perpetual existence. Okay? As for the partnership, indefinite life, pero wala namang indefinite life. Pero may partnership kasi na kino-continue, especially sa mga law firms or mga known partnership firms na kino-continue yung name kahit wala na yung mga original partners. Okay? For dissolution, must have consent by the state. Unlike for partnership, ang kailangan lang na consent dyan, partners eh. Diba? If partnership at will pa yan, consent lang ng isang partner. Diba? Kahit ayaw nung iba, kung gusto ng partner na tapusin yung partnership, walang magagawa yung ibang partners. Okay? So yan yung difference ng partnership and corporation. As to classifications of corporations, ito madami. We have the stock, the number 1 stock, the number 2 is non-stock. I will present it this way so that you can understand and contrast the different classifications of corporation. So for a stock corporation, by the term itself, stock, it has a capital stock divided into shares and are authorized to distribute to the holders of shares, dividends, or allotments of the surplus profits on the basis of the shares. In short, a stock corporation has a capital stock that is divided into shares. These shares are eventually issued to stockholders, wherein the stockholders will subscribe and pay these shares, okay, in return for future dividends or increase in the value of the stock. Okay, yun yung stock corporation. Okay, it has a capital stock that can be divided into shares. Pag non-stock naman, no part of its income is distributable as dividends to its members, trustees, or officers. So unlike stock na you can distribute dividends to stockholders, dito wala. Okay, non-stock. Okay? Meron lang dyan salary. Okay, hindi siya stock, hindi siya dividends. Okay? The next classifications of corporations, you have the domestic and the foreign corporation. When we say domestic, it's one incorporated under the Philippine laws. Most probably that corporation has its official address in the Philippines. While for a foreign corporation, one that is formed, organized, and existing under any laws other than those of the Philippines, so outside the Philippines, and those whose laws allow Filipino citizens and corporations to do business in the Philippines. Take note, most foreign corporations require 60% ownership of Filipino citizens. Ibig sabihin po, sa corporation, yung stock, sa foreign corporation, yung stockholders po doon, dapat 60% Filipinos. But, not all corporations. Madami kasing different kind of laws that can come into play here, especially if engaged sa media, mga ganun yung corporation. It requires different set of percentage, hindi laging 60%. Okay, but generally, mostly kasi, yan, 60%. But not all. Ito yung bago. Corporation aggregate and the one-person corporation. Corporation aggregate, ito yung dati ng existing na corporation before. Ibig sabihin, more than one or at least two, but not more than 15 na incorporators. But subsequently, pwede mag-increase ang kanilang corporators. Ibig sabihin lang yan, madami silang stockholders. Okay? But with regards to one-person corporation, it is composed only of one person. This is the new law. Okay? Single or sole corporation. Sir, bakit? Corporation ka ba kung ikaw din lang naman? Ba't nag-sole proprietorship ka na lang sana? Meron kasi yung mga rich individuals. Before the passage of this law, of this new corporation code, what the people are doing are, especially if mayaman ka, syempre hindi pa pwede noon ang isang tao sa isang corporation. Dapat at least 2 yan ang bumuo niyan. Ang ginagawa usually ng mayayaman, naglalagay sila ng dummy persons. Okay? Acting as stockholders or incorporators para lang mabuo yung corporation na yun. But in its essence or in reality, ang may-ari lang nun is si one person. Ngayon, to eliminate that, kasi ang pangit naman tignan na ganun ang ginagawa, i-allow mo na lang na one-person corporation. That's why there is now a law allowing sole corporation or one-person corporation. Ito yung bago. Then you have public and private corporation. When we say public corporation, one that is organized for the government of a portion of the state. So mostly yan mga GOCCs. For the private corporation naman, one that is formed for a private purpose. O yan, usually yung mga stock corporation. Those that are created mainly for the purpose of making income. But there are private corporations na publicly listed. Hindi sila public corporation. Publicly listed sila with regards to their stocks sa Philippine Stock Exchange. Okay? Then we have the ecclesiastical corporation and lay corporation. When we say ecclesiastical, from the word itself, it's formed for a religious purpose. For lay corporation, one formed for a purpose other than religious. So kung hindi na for religious, lay corporation. Eleemosynary and civil. When we say eleemosynary corporation, one form for charity. Okay? When we say one form ay civil corporation, one form for business or profit. So, as you can see, these corporations, kaya ko sila pinagtabi because they have their opposite definitions. Eleemosynary is for charity, civil corporation is for business or profit. Diba? Magka-opposite sila. Ganun din yung past na mga examples natin. And then we have de jure and de facto corporation. When we say de jure, okay, that is a corporation that has complied with all the legal requirements required by law. Okay, ibig sabihin, na-check niya lahat ng hinihingi ni SEC. Okay, nakapag-comply siya. That is a de jure corporation. Of course, may issue yung articles of incorporation or certificate of incorporation. Okay? When we say de facto corporation, one that is defectively created, but there is an exercise of corporate rights and franchise resulting from an attempt in good faith to incorporate on the part of its partners. Ibig sabihin, hindi lahat ng nasa checklist ng SEC na check, but there is an exercise of corporate rights. Parang mayroong obligations na na-create. Okay? Hindi pa na check lahat ng checklist ng SEC, mayroon nang na-exercise na corporate power. And by virtue of that exercise of corporate power, merong nag-create na obligation, o yun, maging de facto corporation. Iba pa yung corporation by estoppel. Okay? The next one, we have the parent and the subsidiary corporation. When we say parent corporation, one who owns shares of another corporation and having power or control over the latter, including the election of officers thereof. Meaning, let's say for example, Corporation A and Corporation B. Corporation A is the parent corporation. Okay? Ibig sabihin, ito si parent corporation, he owns majority of the shares of subsidiary corporation or Corporation B. Okay? Ibig sabihin, siya ang may control kay B, Corporation B. While subsidiary corporation, one whose shares are owned by another corporation. So, parent corporation owning subsidiary corporation, ito ang nagde-decide. Okay? And then we have closed corporation and open. Okay? If the shares is limited to a few people and not listed in any stock exchange, just like in the PSE, okay, that's what you call closed corporation. Usually, itong mga closed corporations na ito, these are your, what do you call that? Family corporations. Family corporations yung mga yan, yung closed corporation. Ibig sabihin, within their circle lang yung issuance ng shares. Okay? Hindi din siya publicly listed. Unlike sa open corporation, one whose shares are offered to public and is listed to any stock exchange. Okay? Kaya lahat ng pag-aralan nyo sa subject nyo sa FM, sa financial management, ma-apply nyo dito kasi ito yun, nandito lahat yun. Okay? Di ba nga, kapag bago yan, anong tawag mo dun sa initial offering ng stocks ng corporation sa public? Yun yung IPO, di ba? Initial public offering. Ibig sabihin nun, magiging public listed na si corporation. Ibig sabihin, open corporation siya. And then, the last one, corporation by estoppel. Just like partnership by estoppel, ito yung group of persons representing themselves to be a corporation when the truth is there's really no corporation. Okay, we have their corporation by estoppel. So ngayon pa lang dapat alam nyo na yung concept ng estoppel. Ibig sabihin, when you try to misrepresent something or represent something to someone and that someone relied that misrepresentation, okay, you can be stopped from denying. Ibig sabihin, hindi mo pwedeng i-deny na hindi kayo corporation. Why? Because you represented yourselves to be corporation. And sa mga transactions kasi na ganyan, papel lahat yan. Paano ka mag-represent as corporation? Ginagawa niya ng papel at lahat. Ngayon, i-deny mo. Okay? There are also corporations created by special laws or charters. Or ito yung sinasabi natin na ito kasi pwedeng public corporation. Why? These are corporations that are formed by virtue of special laws and charters and shall be governed by the provisions applicable to them. Meaning, when we talk about laws, when we talk about corporations created by special laws or charters, it is not the corporation code or the corporation law that covers their operation, their existence, but rather it is the special law or the charter. Okay? Kapag private corporations yan, usually ang nag-govern dyan yung revised corporation code or yung corporation law. Okay? Kapag kasi gawa yan by special law, ibig sabihin ginawa ng Congress, ginawa ng state, ng government, or through a charter, okay, most probably kasi yan, yan yung public corporation. Okay? Ang nag-govern sa kanila, hindi yung corporation law, but rather, it is the special law or the charter that created that corporation. Okay? Like SSS. Okay? Merong Social Security Law. And also, para makarelate kayo more, like CSU. Okay? It's created by a charter. So, yun ang nag-govern sa kanila. Hindi yung corporation code. Okay? Components of a corporation. Very simple. Hindi na bago ang words na ito sa inyo. Those who comprise the corporation includes stockholders, of course, members when it is a non-stock, and incorporators. Okay? Those stockholders or members mentioned in the Articles of Incorporation as original forming and composing the corporation and who are signatories thereof, ito yung incorporators. Why? Incorporators are those stockholders that are mentioned in the Articles of Incorporation, and they are the ones who originally formed the corporation. Okay? And then there are those corporators of a stock corporation, corporators of a non-stock corporation, and then a person who usually discovers a prospective business and brings persons interested to invest in it through formation of a corporation. Ito yung tinatawag natin mga initiators. Diba? Some corporations start like that. Through proposal, business proposal, and then after that, if they can see that that business or that idea is a viable business, then people can look for investors. Yun ang gagawa. Sila yung gagawa ng corporation. Yun yung mga initiators. Yun. Or originators pala. Initiators, originator ang tawag. And then we have, gaya nga lang sabi natin kanina, corporators and incorporators. Corporators kasi, they compose the corporation. They are the stockholders in a stock corporation or non-stockholder members in a non-stock corporation. So, dalawa yan, either shareholders or members. Kapag incorporators kasi, sila yung stockholders na nakasulat yung pangalan nila sa Articles of Incorporation. Okay? Kaya incorporator, sila yung una na nag-create dun sa corporation. Okay? Shares. We have shares of stock. One of the units into which the capital stock of the corporation is divided. Diba ang sabi natin, a stock corporation has a capital stock. Okay? And that capital stock is divided into shares of stock. Yun yung shares of stock. Okay? And that shares of stock is evidenced by what we call a stock certificate. Okay? That stock certificate is a written acknowledgement by the corporation of the stockholders' interest in the corporation. In other words, it's your evidence of your interest in the stockholders, interest in the corporation. Yun yung evidence mo diba? When you say par value stock, these are nominal value of which appears to the stock certificate. If that certificate has a value appearing in it, that is a par value stock. If it does not have a value, it's what you call no par value stock. Okay? The classification of shares, their corresponding rights, privileges or restrictions, and their stated par value, if any, must be indicated in the Articles of Incorporation. So you have to take note the importance of Articles of Incorporation. Dapat lahat na, kumbaga, nandun na sa Articles of Incorporation regarding rights, privileges, or restrictions. Okay? Each share shall be equal in all respects to every other share, except as otherwise provided in the Articles of Incorporation and in the Certificate of Stock. So, general rule, each share shall be equal in all respects to every other share. Okay? Unless merong nakalagay sa Articles of Incorporation or Certificate of Stock regarding different rights as regards the share. Okay? The shares in a stock corporation may be divided into classes or series of shares or both. Diba? Pwede kasing common or ordinary share A, common or ordinary share B, diba? Preferred stock A, preferred stock B, diba? Cumulative preferred stock A. It can be different series of shares. And then non-voting shares. It's better if we try to distinguish voting from non-voting shares. When we say voting shares, these are holders of shares that are entitled to vote in the meeting of the corporation. Okay? But non-voting kasi, as regards to the meeting of the corporation, they don't vote. Okay? But, yun ang sabi dito, no share may be deprived of voting rights except those classified and issued as preferred or redeemable shares unless provided by this code. Ibig sabihin, yung usually na non-voting shares, ito yung preferred share or redeemable share. Okay? Provided that there shall always be a class or series of shares with complete voting rights. Take note, in a corporation, okay, in a corporation, there should be shares or class of shares na mayroong voting rights. Why? Because itong mga to, sila kasi yung involved sa decision making ng corporation. Kaya dapat meron. Hindi lahat non-voting. Okay? The general with that is no share may be deprived of voting rights except preferred or redeemable. Exception to exception, otherwise provided in this code. Okay, but, sir, kapag non-voting share ba, automatic? Wala nang right na mag-vote? Ganun po ba yun? Hindi ganun yun, okay? So, when we talk about non-voting shares, meron pa ring right to vote. Okay, meron pa ring right to vote yan. Sabi nga sa Revised Corporation Code, holders of non-voting shares shall nevertheless be entitled to vote. So, yung non-voting shares, yung holders of non-voting shares can still vote. Okay? Ano yung pwede nilang pagbotohan? With regards to amendment of the Articles of Incorporation, adoption and amendment of bylaws, sale, lease, exchange, mortgage, pledge, or other disposition of all or substantially all of the corporate property. Because, take note, these shareholders are still owners of the corporation. Diba? May say pa rin sila, although non-voting shares ang hawak nila. Kasi meron silang hawak dun sa corporation, may ownership sila, may interest sila. Okay? And then, incurring, creating, or increasing bonded indebtedness. Precisely, as owners, kapag mag-create ng utang, di ba, ng obligation, ng indebtedness, they must have a say in the corporation. Kaya kahit non-voting shares yan, meron silang right to vote. Increase or decrease of authorized capital stock. They have the right to vote. Why? Kasi affected din ang shares nila dyan. Merger or consolidation of the corporation, precisely they are owners. Diba? Investment of corporate funds in another corporation, just like in merger or consolidation. Then, dissolution of the corporation. You take note of this kasi importante yan. Except as provided in the immediately preceding paragraph, the vote required under this code to approve a particular corporate act shall be deemed to refer only to stocks with voting rights. Meaning, okay, when it is with regards to a corporate act, ang mag-vote lang dyan is those holders of voting shares. Yung mga common stock, ordinary stock na doon. Pero kapag itong mga to, A to H, mag-vote dyan ang non-voting rights. Okay, involved sila dyan. Classes of shares of stocks. Okay? Number 1, common or ordinary stock. Entitles the holder to a pro rata division of the dividends without any preference over other stockholders. Okay? It's a common stock. It's an ordinary stock. It shares in the dividends, but it has no preference over other stockholders, comparing it to preferred stock that the holder of a preferred stock has preference other than other stockholders or other than those holders of common or ordinary stock. Okay? Kinds of preferred stock. You have cumulative preferred stock and non-cumulative preferred stock. When we say cumulative preferred stock, cumulative, ibig sabihin, nag-accumulate siya. The holder for payment not only to current dividends but also those in arrears before holders of common shares are paid. Meaning, let's say for example, year 1, year 2, year 3. Okay? Year 1, hindi nag-declare ng dividend si corporation. Okay? So may arrears dun. Year 2, ganun din. Year 3, saka lang nag-declare. Okay? Ngayon, pwedeng mag-accumulate yun kung meron kang cumulative preferred stock or if you are a holder of cumulative preferred stock. Ibig sabihin, may right ka to share in the current dividends for year 3. And at the same time, you can also get your dividends for year 2 and year 1 in yung cumulative preferred stock. Okay? Cumulative and my preference. For non-cumulative preferred stock naman, okay, the holder is entitled and has preference only with regards to current dividends. Hindi siya nag-accumulate, non-cumulative. Participating preferred stock and non-participating preferred stock. When we say participating preferred stock, the holder is entitled to participate with the holder of the common shares in the surplus profits after the amount stipulated has been paid to holders of preferred shares. Ito kasi, kapag preferred stock ka na, may preference ka over common stockholders. Okay na yun. So, ikaw muna ang babayaran. Pag nabayaran na lahat ng preferred stockholders, okay, next na yung ordinary stockholders. Ngayon, because we are talking about participating preferred stock, meron ka ring share dun sa ordinary stock. Okay? Meron ka ring kasali ka din dun sa dividend distribution. Okay? With regards to those ordinary stocks. Yun yung ibig nating sabihin. Okay? For non-participating naman, only to the amount stipulated paid to holders of preferred shares. So, preferred stock lang siya, non-participating. Unlike yung sa participating, nakuha mo ng share mo as a preferred stockholder, magpa-participate ka pa sa surplus with regards to common stockholders. Yun yung maganda doon. Other classes of shares, we have redeemable shares from the word itself. Okay? The corporation can redeem or purchase the redeemable shares either at a certain period or at a condition given, ganon. Okay? Redeemable shares. Founders shares, those which grant to founders certain rights. Okay? Ibig sabihin, if you're a holder of a founder share, you have specific rights that are only available to the founder shares. While treasury shares naman, okay, these are shares that have been issued by the corporation, fully paid by the stockholder, but subsequently required by the issuing corporation. Pwedeng by purchase, redemption, donation, or to some other lawful means. Okay? Iba siya sa redeemable shares kasi ang redeemable shares, meron siyang time period talaga na pwedeng i-redeem ng corporation. Comparing it with treasury shares kasi, na issued siya, na subscribe, na paid, fully paid, pero binili ulit ng corporation. While watered shares naman, okay, those issued without compensation or with no adequate consideration. Let's say for example, a stock is sold 50 yung kanyang par value. Okay? So dapat pag binenta siya or inisyu siya, it must be issued at 50 par value, di ba? Pero pag yan binenta or inisyu at let's say 30 par value or 20 par value, watered share po yan. Why? Kasi you are issuing a share of stock worth 50 pesos pero ang natanggap mo lang is 30 or 20 pesos. Para siyang tubig. Diba? Tubig kasi, pag tubig, akala mo, let's say for example, may baso. Akala mo dito yung level, diba? Ng tubig. Pag ginanya mo yung kamay mo pala, papasok pa, mayroon pang butas, parang gano'n siya. Okay? Kaya siya tinawag na watered share. Okay? Kasi it is issued at a price lower than its par value. That is a better term for that, watered share. It is issued lower than its par value. Okay? I hope you can follow. Incorporation and organization of private corporations. Ito na. In organizing private corporations, ito yung kailangan nating gawin. These are the steps. You have to verify with SEC of the name to be used. Very important yan. Yun yung first na step. Why? To avoid trademark infringements and confusions as regards the name. Diba? Tatayo ka na ng corporation, ang name niya Jollibee. Tapos nagbebenta din kayo ng chicken, ganoon din. Tapos yung kulay niya red, ganoon. 'Di ba? Hindi pwede 'yon kasi it will confuse people. Okay? Ang worst kapag pangit ang mga order nyo, ay pangit yung food, yung service and all, it can cause damage to Jollibee. Why? Kasi mamaya akala ng tao Jollibee yun. Jollibee pala. Iba pala yun. No corporate name shall be allowed if the proposed name is, ito na ata yung sinasabi ko, identical or deceptively similar to any existing corporation or any other name protected by law. Okay? Diba? If it's identical or deceptively similar, akala mo parehas, diba? Malay mo, ano pang pwede natin gamitin na example? Ngayon, Jollibee, ganun, mga ganun na mga name. Parang, madami. Basta, ang point is that the name of the corporation should be verified as to avoid any deceptive names, okay, by those that have existing corporations. Patently deceptive, confusing, or contrary to existing laws. So, hindi rin pwede yung against the existing laws. Okay? Kita mo naman yan if the corporation is formed basically just to induce confusion among the people or to try to get the goodwill kasi of the other corporation. Diba? May mga ganun. Drafting and execution of articles of incorporation signed by the incorporators. Of course, if verified the name nyo with the SEC, you can now draft and execute your articles of incorporation. Then after executing the articles of incorporation, you have to file it with the SEC. Then after filing, you have to pay for the filing fees, the publication, and other fees. Meron dyan mga DST pa, doc stamp. Then, issuance of Certificate of Incorporation by SEC. Gaya nung sabi natin kanina dun sa comparison with partnership, sakalang magbibigin yung corporation life when the Certificate of Incorporation is issued by the SEC. So, pag na-issue na yon, your corporation is deemed existing. Contents of the Articles of Incorporation. Ang sabi natin kanina, we have to draft and execute the Articles of Incorporation. Actually, under the law, mayroon na siyang form. Makikita mo na siya doon. Andun na kung paano mo siya fill up. Okay? Nakalagay doon yung name of corporation. Diba? Yun yung pinakauna. Purpose of the corporation. Place or the principal office. Of course, if domestic yan, dapat sa Philippines. The term of existence which is 50 years and extendable. The names, nationalities, and residences of incorporators, which the majority should be residents of the Philippines, and must be at least a subscribe of 1 share of stock. Meron kasing rule tayo dyan, but mamaya-maya pa yun siguro i-discuss natin. Names, nationalities, and residences of BODs or BOTs. Amount of authorized capital stock, number of shares divided, and par value of each. Names of subscribers, nationalities, shares subscribed, and amount paid in must not be lower than 5,000 pesos. Okay? Other matters, these other matters kasi at the option of the incorporators, kung ano yung gusto nilang idagdag sa Articles of Incorporation. Diba sabi natin before, you can already put there those rights that come with the shares that is to be issued by the corporation. Diyan mo na pwedeng ilagay. And then name of temporary treasurer, elected, notarial acknowledgement. These are the requirements na kasi. Okay, and affidavit. Ngayon, once you have drafted and executed your Articles of Incorporation, of course, there are times when you have to make changes or you have, baka meron kang mga you need to amend. You can amend the Articles of Incorporation. How? There must be a votation. Dalawa ito, hindi either of these two or hindi either of these two, dapat dalawa ito. Ang mauna mo na sa majority vote of directors. Why? Because the board of directors are the ones who manage the corporation. So if they decided that they want to amend the Articles of Incorporation, they must do it by a vote of majority. Tandaan, majority Ibig sabihin, 50% plus 1. And then after that, the vote or the written assent of 2/3 of the outstanding capital stock or members. Okay, because you are going to affect the whole corporation. Why? Because you are changing or you are amending the Articles of Incorporation. That's why you still have to get the vote or the written assent of the 2/3 of the outstanding capital stock or members. Okay, so majority vote and then vote or written assent of the 2/3 of the outstanding capital stock of the members. Upon approval by the SEC or from the date of filing with Commission, if not acted within 6 months, it will take effect. So, if you filed for an amendment of the Articles of Incorporation, okay, once it is approved by the SEC, it will take effect. But if after you file for the amendment of the Articles of Incorporation and the SEC did not act within 6 months from the date of your filing, yan is considered as effective. Okay? So, mayroong time at play. Dapat ma-act yan within 6 months, otherwise effective yung amendment sa Articles of Incorporation. Then we have the provision for continuous non-operation. We have to distinguish this with delinquent corporation. Kapag continuous non-operation kasi, ibig sabihin, from the start, it did not commence or formally organize. Okay? Ibig sabihin, from the start up to 5 years, okay, it did not commence or formally organize yung corporation. It will be revoked. Okay? The certificate of corporation or certificate of incorporation shall be revoked. Okay? Unless that non-commencement or the fact that they did not formally organize is due to causes beyond the control of the corporation as may be determined by the SEC. Siguro pwede mo, like for example, now, siguro sobrang hirap, you are not able to commence or formally organize. That could be. Okay, that could be an excuse. But generally, kung 5 years ka lang kung 5 years simula na na-approve yung SEC, yung Certificate of Incorporation mo, hindi kayo nag-commence, hindi kayo nag-start, hindi kayo nag-formally organize, and 5 years na, the Certificate of Incorporation can be revoked. Now, compare that with delinquent corporation. When we say delinquent corporation, a corporation has commenced its business. Diba? Unlike dun sa kanina, it did not commence or formally organize for 5 years. Dito naman, it commenced and organized. But it becomes inoperative for a period of at least 5 years. Malay mo, for 3 years nag-operate sila or nag-commence sila. But now, 5 years na silang hindi nag-cooperate. Okay? A delinquent corporation shall have a period of 2 years to resume operations and comply with all the requirements that the Commission shall prescribe. Otherwise, its certificate shall be revoked. Okay? Yun lang naman yun. So, with regards to continuous non-operation, from the beginning, walang operation. 5 years, revoke kaagad. Okay? Pwedeng ma-revoke. While for delinquent corporation, nag-commence sila, nag-organize, but then eventually, siguro nag-operate din, but eventually, they failed to operate for 5 years or at least 5 years. Ibig sabihin, mayroong chance ang corporation kapag delinquent siya to operate for 2 more years. Kapag wala, the certificate shall be revoked. Ganun yan. Let's go to capital stock terms. Of course, ito, alam niyo na to, familiar na kayo dito. Everyday niyo itong binabasa sa mga major nyo. Capital stock, amount specified in the Articles of Incorporation, paid for carrying on the business of the corporation. So that's the capital stock. Yung amount na nakalagay sa Articles of Incorporation. Yung authorized capital stock naman, these are the total amount of stock which a corporation is allowed to issue. So meron kang capital stock, yung nakalagay sa Articles of Incorporation. Then, meron yung authorized capital stock na from this capital stock, ito lang yung allow na ma-issue. Yun. Yung authorized capital stock. Okay? Yung subscribed capital stock naman, ito yung part ng capital stock na na-subscribe ng stockholders. Okay? Diba? Ang stockholders, hindi naman kaagad mag-i-issue yan. May subscription pa yan. Magsusubscribe muna si stockholder, yung total na na-subscribe, yun yung subscribed capital stock. Ang outstanding capital stock naman, these are total shares of stock issued to subscribers or stockholders, whether not fully or partially paid except treasury shares. So ito, these are total stocks na na-issue or na na-subscribe. Okay, yun yung outstanding capital stock. Whether bayad yan or hindi, yan yung OCS mo. Okay? While yung paid up capital stock mo naman, this is part of the subscribed stock paid to the corporation. Diba? Sabi natin kanina, yung stockholder magsusubscribe. Okay? Ngayon, yung subscription yun, yun yung tinatawag nating subscribe capital stock. Ngayon, kapag binayaran niya yung portion nun, yun yung tinatawag nating paid up capital stock. Pero kunin mo yung total, hindi lang si isang shareholder. Okay? And then, unissued capital stock, part of capital stock which is not issued nor subscribed. Ibig sabihin, from the capital stock na sinabi natin kanina, yung una, di ba yung capital stock, meron lang i-authorize na capital stock. Yun lang yung may issue. Yung hindi na issue, yun yung tinatawag nating unissued capital stock. Okay? I hope that's clear. And then last, legal capital. Total par value of all issued par value shares or total cash or consideration received for all issued no par value shares. So that's it for our first topic. So I hope that you've learned something. I'm very much confident naman na you already know the basics of corporation. Mag-focus tayo more sa next na topic natin. Thank you.